Hi, today we're talking about what are the detailed steps in stage 1 of a divorce. Stage 1 of a divorce involves the following individual steps. A. If you are starting the divorce process and submitting the divorce application to court, you will be the plaintiff and your spouse will be the defendant. If your spouse has committed adultery, the third party will be referred to as the co-defendant. If your matrimonial assets include an HDB property, an HDB flat, your divorce lawyers will send a standard query form to the HDB and CPF Board to calculate the amount for the flat and also the CPF balance, and also give the court the required information regarding things such as your ownership payments already made by you and your spouse and the outstanding balance relating to the HDB property. Also, you and your spouse's proposals on what will happen to the flat after the divorce, whether HDB agrees and consents or objects to your proposals, and if your proposals will be affected or disrupted by any special HDB policies regarding things such as the minimum occupation period or special subsidies. The information responses given by HDB and CPF will form part of the proposed or agreed matrimonial property plan, which you must also submit as part of your divorce application papers. This process will take about a month to complete, and you won't be able to start your divorce if you don't already have the CPF and HDB responses, unless you have the court's permission to do so. C. To start the divorce process, you must submit these documents to court: the writ of divorce, the statement of claim, which is a summary of the key facts that you are relying on and explaining why you should be granted the divorce. You must also submit the statement of particulars. This gives full details of the facts you've written about in your statement of claim. There's also the proposed parenting plan. You must file this if your children are below 21 years old. There's also the agreed parenting plan. You must file this if you and your spouse have reached an agreement on living and care arrangements for the children after the divorce, and if you are applying for an uncontested divorce, meaning a consent divorce. There's also the proposed matrimonial property plan, and you must file this if an HDB flat is to be divided between you and your spouse. There's also the agreed matrimonial property plan. This is only filed if you and your spouse have managed to agree on what to do with the HDB flat after the divorce. The acknowledgement of service is something to confirm that the divorce papers have been properly served and delivered to you. There's also the memorandum of appearance, and this gives advance notice to the court that you or your spouse intend to participate in the proceedings and give your response to the claim made against you. Once the writ for divorce has already been filed in the family court, the writ will be also served or delivered on the defendant via personal service if the address of your spouse, the defendant, is known to you, the plaintiff. If the court papers cannot be successfully delivered to the defendant after 2 attempts, you, the plaintiff, can apply to the family court to have permission to deliver or serve the papers in an alternative way, such as through substituted service. And this includes mailing the papers to the last known address of the defendant, also to post the papers in the family justice court, or sending it via registered post to the last known address of the defendant, or by email. If the plaintiff doesn't know or is unable to find the defendant's address, the plaintiff can apply to the Family Justice Court for permission to deliver information of the papers to the defendant by advertising in the information section in the newspaper. Later, once the divorce papers have been served or delivered successfully on the defendant, he must then file a memorandum of appearance within 8 days if he intends to challenge the divorce or ancillary matters. This document gives advance notice to the court and your spouse that you intend to participate in the proceedings and give your response to the claim made against you. If the defendant fails to file this on time, the plaintiff can proceed to file an affidavit of service and to set down the matter for trial. After this, if the defendant is not contesting the divorce, a hearing date and a trial date will be fixed and given by the court. If the defendant is contesting the writ, he must then file a defense in the family court and deliver these defense papers on you, the plaintiff. If no defense is filed in court by the defendant within the given time limit, the court will consider the case as being unchallenged or uncontested by the defendant. If the divorce is being contested, a hearing date will be given by the court, and The couple will usually be given permission by the court not to attend. At the hearing, the judge will decide if there is sufficient evidence to grant a divorce, and if so, the judge will grant a provisional divorce by issuing a court order called an interim judgment. This interim judgment is usually finalized and regarded as being final and conclusive and binding on the couple after 3 months. If the divorce is contested or being challenged, an administrative court hearing called a pretrial conference is conducted to look into whether there are common areas where parties can agree, which would help to reduce the area of disagreement that the court needs to decide on. Mediation is also sometimes arranged to help provide more opportunities for parties to come to an agreement on more issues. If the PTC or mediation is not successful, a hearing is then scheduled, and if the case is being contested or challenged by the plaintiff and the defendant, each of them and their witnesses will need to give evidence in court by submitting written statements called affidavits, and they will be asked questions, meaning they will be cross-examined on what is stated and written in their affidavits. In many cases, a divorce is handled on an uncontested basis, and only the ancillary matters are left to be handled on a contested basis. So, there you have it, some very basic information about what are the detailed steps in stage 1 of a divorce. Thanks for watching.